Today's speakers are Nicholas Sharp and Jonathan Lennon. Nicholas Sharp, Legal Director of Rahman Ravelli, is recognised in the legal directories for her extensive experience and expertise in some of the most significant and demanding civil fraud and white-collar crime cases. Her practice includes major global energy sector investigations, complex multi-jurisdictional litigation involving asset recovery and enforcement, and notably high-value cases under Part 5 of POCA. Her client list includes corporates, senior business figures, and high net worth individuals. Rahman Ravelli represented Mr. Gale, the appellant, in the first civil recovery order to be considered by the Supreme Court. Jonathan Lennon is a recognised leading senior junior criminal practitioner who has recently joined Doughty Street and the Business, Crime and Investigations team. Jonathan's practice is principally in defending in white-collar crime and associated POCA litigation in both criminal and civil jurisdictions. He was junior counsel in the Supreme Court for Mr. Gale, and he represented Carol Angus in the leading case on cash forfeiture under POCA. Jonathan is instructed to represent corporates and individuals in many Part 5 POCA claims, including account freezing and forfeiture orders. Nicola, Jonathan, over to you.
Thank you, Richard, and welcome everybody to today's webinar. Now, we've rather boldly called this webinar Criminal Practice in a Civil Age, and that's because we sense that there is a more and more use by law enforcement agencies of the civil part of the Proceeds of Crime Act, POCA, namely Part 5. Now, in this webinar, we're going to talk about two things, both separate but very much related, and that's civil recovery orders and account forfeiture orders. So firstly, civil recovery orders, effectively orders which recover property that is said to be the proceeds of crime. This can be any property, cars, paintings, houses, anything. Civil recovery claims have been with us since POCA came into force, and they are orders that are made in the High Court. Usually before a claim is issued, the National Crime Agency or other prosecuting authority will freeze the assets by way of obtaining a property freezing order, and this can be made with or without notice. Secondly, account forfeiture orders. Now, these are fairly new, have been around since April 2018. The target for these orders is cash held in bank and building society accounts, and unlike property freezing orders, these are actually made in the magistrate's court. Applications are generally made directly by the investigating agency rather than, say, the Crown Prosecution Service, and usually by a police officer or HMRC. The process is started by the applicant securing a with or without notice freezing order called an account freezing order. So there are clear similarities between property freezing orders and account freezing orders, main difference being the appropriate court to which the application is made. Now, with Part 5, whether it's High Court or Magistrates Court, there's no need for the applicant to go through all the trouble of proving that the defendant is guilty of a criminal offence. Merely, they just have to prove, to the civil standard, that the property is probably the proceeds of crime. Now, interestingly, the Home Office produced earlier this year an asset recovery statistical bulletin. This looked at the years 2014-15 through to 2019-20, and here are some reported statistics. By the end of the financial year 2019-20, 208 million had been frozen in that one-year period, covering 812 bank and building society accounts, all using account freezing orders. The bulletin also looked at 6 years, 2014 to 2020, and the lowest year for criminal disposals by way of confiscation is 2020, with a recorded 139 million. Meanwhile, the highest year for forfeiture, both cash and bank accounts, is, you guessed it, this year, 2020, with a reported 69 million. Now, the drop in criminal disposals is clearly matched by the pickup in civil disposals, and we suggest this is not a coincidence. It's because of the introduction of account freezing orders. Add to this the increase in suspicious activity reports, and we suggest the only way is up for civil disposals. And we see civil disposals being used where criminal prosecutions and the risks and the protections that come with it are being more and more replaced by civil procedure. I'd also suggest that COVID has no doubt had its influence on this trend, as the amount of civil applications seems to be accelerating. One thing's for sure, the criminal defence industry is becoming a lot more civil. Now, of course, criminal allegations in a civil action are nothing new. Cash forfeiture, High Court civil recovery proceedings have been with us for years. Failed prosecutions in the Crown Court morphing into claims in the High Court are almost commonplace now, especially in drug trafficking allegations. But now we also have unexplained wealth orders, for example. Now, these have been inserted into Part 8 of the Proceeds of Crime Act by the Criminal Finances Act 2017. And though it's fair to say that they're utilised few and far between at the moment, this may well change. The same, however, cannot be said for the other significant addition to POCA by the 2017 Act, and that's account freezing orders and account forfeiture orders. These have been inserted into Part 5 of POCA, which is the civil part of the Act. Now, we'll look at the law around Part 5 of POCA, and in particular, the law from civil recovery and cash forfeiture regimes in due course, as these will apply equally to the new account freezing order powers. Now, unfortunately, there's a time limit as to how much we can cover in a short webinar, but we will be looking at the mechanics of how account freezing orders work in practice shortly. But first of all, I'd like to say a little something about High Court civil recovery proceedings. Now, originally, when POCA came into force, it was just the Assets Recovery Agency that dealt with civil recovery. The ARA was actually created by POCA to take out civil recovery actions and was in fact the only body at the time that could take claims forward. The ARA are now defunct. Now, High Court civil recovery claims can be issued by all major prosecuting agencies, but in practice, it's the National Crime Agency that are the lead agency and take out the most civil recovery claims. Certainly all the civil recovery cases I'm currently dealing with at the moment have been brought by the NCA. Now, it takes a very long lecture to do any kind of justice to the civil recovery applications in the High Court, but in short order, the process will typically be along the following lines. Police force will have investigated a suspect, but have decided, or the CPS have decided, that the case of, say, fraud cannot be proven to the criminal standard. So they refer the case to the NCA for possible civil proceedings because there is a number of assets, there's money in bank accounts. The NCA will start the civil recovery investigation and will seek what's called a property freezing order under section 245A of POCA. This will normally be made without notice on an application to the High Court. All they have to prove is a good arguable case that the property is recoverable property. Now, John will deal with what recoverable property is in a moment, but it's important to note that this also applies to account freezing orders. They have the same concept. Now, the NCA will usually secure at the same time as the property freezing order, a disclosure order. And this acts almost like a roving warrant, and it enables the NCA investigator to issue notices under the disclosure order to, for example, banks to produce bank statements, and it can also be used to compel the respondent to a compulsory interview. Now, the property freezing order will have a time limit, and within that time limit, the NCA must formally issue its claim for civil recovery. The evidence will usually be from one person, the financial investigator, referencing dozens of other documents, bank statements, police investigations, interviews. And within the statement of the financial investigator, they'll go through each item of property that's in the property freezing order, and it'll have its own section, and the financial investigator will in each case say that each item of property has been demonstrated on the balance of probabilities that it is the proceeds of fraud and is therefore recoverable property. Now, looking at account forfeiture orders, now all of us will be familiar, I would have thought to some extent, with cash forfeiture regime in the Magistrates Court. That you can find contained in Chapter 3 of Part 5 of POCA. The account freezing and forfeiture regime is modelled upon it, both in concept and in procedure. The fact that the 2017 Act created two new parts to Chapter 3, Parts 3A and 3B. 3A deals with the seizure of listed assets. So this is where the police, for example, say that physical assets such as watches, paintings, etc. are recoverable property. But at the moment, we're not really seeing that being used much in practice. Of more importance, especially for today's webinar, is the insertion of Part 3B, and this relates to money held in bank and building society accounts. And this is being used now more routinely than ever for increasing sums and ever increasing complexity of cases. And all of this is being dealt with in the Magistrates Court. I'll come back to the detail of the process later, but the basics are the same. The police have their investigation, they obtain their account freezing order, and the test for obtaining it is reasonable grounds for suspecting. So it's a very low threshold. They then make their claim within 2 years because there's a time limit of 2 years on an account freezing order. And the evidence again will typically be from one officer, again referencing tax issues, bank statements, etc. and arguing that the money in the bank account is either recoverable property or is intended for use in unlawful conduct. And John will take you through more of that test in a moment. But in short, we see Part 5, and in particular account freezing orders, as the growth area for the criminal justice industry. But now we're going to turn to a little bit of black letter law, and so I will hand you over to John.
Thank you very much, Nicola. Before I come to the case law, just a couple of two very quick things. First, at the end of my bit, Nicola is going to take us through the detailed procedure on getting an account freezing order or challenging an account freezing order, and instead of going for account forfeiture orders. Secondly, I'm going to now talk about the concept of recoverable property and some of the concepts that are contained in Part 5 of POCA of the Act. But first of all, we need to just understand what the end products are, and by that we define orders. So in the High Court, when it's a claim for High Court civil recovery, a civil recovery order, it's what it says on the tin. The NCA want a civil recovery order, and they can get that only by proving one thing, that for each item of property listed, that each of those items is recoverable property. And we'll come on to that test in a moment, but recoverable property just means the proceeds of crime. In the Magistrates' Court, it's slightly different. In the Magistrates' Court, there are two ways that the law enforcement can get their order. One is by proving that the money, whether it's in a bank account or it's cash, is recoverable property. Or secondly, whether that money is intended by any person for use in unlawful conduct. So normally that, traditionally, that hasn't been the route that's been taken, because that requires the police officer, whoever's presenting the case, to really have a crystal ball and say, well, you know, we think this money is going to be used for this purpose in the future. Now, I'm mentioning all that now at the outset because we'll see with the case law that we're going through that things are slightly changing, and Lim 2 seems to be on the rise. But recoverable property, nonetheless, is still the mainstay of account forfeiture applications and obviously for High Court civil recovery. So what is recoverable property? Well, the test could not be more easily stated. It's in section 304 of the Act, and it's simply this: property obtained through unlawful conduct is recoverable property. It's as simple and straightforward as that, but it brings up two phrases: obtained and unlawful conduct. So unlawful conduct, what's that? That's section 241, and it's very straightforward. It just means crime. So it's crime wherever it's committed, as long as it's a criminal offence here in the United Kingdom, and if the police or the agency concerned are relying on offences overseas, then it's an offence in that country too. So that's normally quite straightforward. But what about obtaining? Property obtained through unlawful conduct is recoverable property. Well, that's section 242. And that says this: in deciding whether any property was obtained through unlawful conduct, it is not necessary to show that the conduct was of a particular kind if it is shown that the property was obtained through conduct of one of a number of kinds, each of which would have been unlawful. So it's quite difficult to do black letter law by Zoom, but all that means is the police don't have to prove that the money that they're after came from a bank robbery which happened, for example, 2 years ago. But they do have to say that the money is the proceeds of bank robberies, or drug trafficking, or gun trafficking, or fraud. They have to point to a particular kind of conduct. It's not enough just to say it's the proceeds of crime. Lifestyle is not enough. This came up in one of the very early High Court civil recovery cases taken up by the Assets Recovery Agency. It was a case of Assets Recovery Agency and Green, 2005 case, preliminary issue, decided by Mr. Justice Sullivan. And the question was, could a claim for civil recovery be determined without identification of any particular type of unlawful conduct, where a respondent has no sufficient identifiable lawful income? Answer, no. Mr. Justice Sullivan, as he then was, went on to say that no claim for civil recovery can be based solely on evidence of lifestyle. There had to be evidence of some kind of background offending. The crucial point, of course, is that That's High Court civil recovery, but it has equal application in the Magistrates Court, as we'll see. So that was Green in 2005. Then the next case that came along following that is Assets Recovery Agency and Alupatan in 2008. It was a Court of Appeal case. And in that case, the Court of Appeal said, yes, it's all very well about Section 242, but a failure to account for your lifestyle or giving a false explanation about a lifestyle could lead to the inference that the property was recoverable property. It's probably no more than just an evidential point. But add to those two cases, 3 years later, was a cash case. It's another Part 5 case. In this case, which is already mentioned, Carol Angus and UKBA. It was a appealable road case stated in 2011. And as Richard's mentioned, I was counsel for Carol Angus. It was an important case at the time, and it's becoming important again, or it may become important again, because the facts need to be understood to really understand the point. Carol Angus, as a Chinese lady living over here at the time as a student, but she was a frequent flyer back to her family in Hong Kong. She came from a very, very wealthy family, and her family, both here and in Hong Kong, were big-time gamblers, often spending time in the casinos at Curzon Street in Mayfair, spending often obscene amounts of money on a nightly basis. On the time she was stopped going out to Hong Kong at Gatwick Airport, she was found to have £40,000 in cash in her handbag, and she gave a quick dismissive explanation of it to the officer, which was false. And on her account, she just said something to get the officer out of the way and couldn't be bothered to explain all the detail of what the money was actually for and where it was from. It was fairly obvious that most of the money was from a casino because the Aspinall's wrappers were still round much of the cash. Nonetheless, the officer seized the money as he suspected it was recoverable property, proceeds of crime. And the Magistrates Court made the forfeiture order, and it went on appeal to the Crown Court. And that's where I was instructed at the Crown Court. And the defence position, our position, was very straightforward. It was that the money was the proceeds of gambling. There was lots of live evidence given about why she was carrying the money. And there was no background offending that the agency could point to. UKBA, for their part, said, well, we don't have to. We just say it's cash. Despite what I've just said about Section 242 and Green, etc., there was another case called Manika and HMRC, 2005 case, which was another cash at the airport case, an Albanian guy. And Mr. Justice Moses basically said in that case, well, when you're carrying large amounts of cash, cash in and of itself, carrying large amounts of cash these days is inherently suspicious. And so it was argued the prosecution agencies in that sort of situation do not have to prove what the underlying offence is, despite the plain wording of Section 242. There was a difference in the application between the High Court and in the Magistrates Court. So on appeal to the High Court, that argument was made that it can't be right that Section 242 had some kind of special and different application in the Magistrates Court than the High Court. And the court agreed. They said that to place upon it that sort of meaning was not simply strained and unreasonable, it was bad law. And Manika was bad law. But along the way, during the argument, the position taken, and this was argued in the Crown Court as well, was that the agency could argue that the money was, the background offence was money laundering, because the argument went that money laundering is a criminal offence under Part 7, and those of us that are criminal practitioners, and most of us here will be, know full well that all the money laundering offences are there set out in Part 7 and rely on the concept of criminal property. So it's not recoverable property, it's criminal property. And that's an entirely different beast Section 340 sets out the definition of criminal property. So criminal property is property that constitutes a person's benefit from criminal conduct. That's it. No kind or kinds, no further gloss on it. It's very different from the concept of recoverable property. So the argument went in the High Court. And of course, with criminal prosecutions, the prosecution rely on the case of Anwar, which, as again, those of us practicing crime will know very well. 2008 Court of Appeal case where the prosecution's job was made quite clear in money laundering prosecutions. That they could prove that the money was criminal property if they could point to a particular offence. And where they couldn't point to a particular offence that the money was said to come from, then they could rely on the irresistible inference, if it was possible to do so, the irresistible inference from all the surrounding circumstances that the money could only come from crime without having to identify what that crime was. So you know the sort of scenario, the cash being handed over in the car park late at night, a carrier bag full of cash. The irresistible inference is that it's the proceeds of crime, but we don't know what crime necessarily. And of course, the difference is that in the Crown Court, there's a very low hurdle to jump to the prosecution in that sort of case. It's just the proceeds of crime, and they're not sure what sort of crime it is, but it looks dodgy. But they have to prove that to the very high standard, the criminal standard. Whereas in the High Court and in the Magistrates' Court, the standard is low. You only have to prove it to the civil standard, but the bar is accordingly raised. You do have to point to some kind of offending. And that's why Parliament, or so the argument went, made the difference that it did between criminal property and recoverable property. So to borrow the case law of Part 7 to get home on Part 5 simply didn't work. Mrs. Justice Nicola Davis seemed to agree, because she's quoted the case of Anwar and said that the idea that Anwar was concerned with criminal proceedings, and the relevant provisions were condemned in Part 7 of the Act in Section 242 form no part of the court's consideration. And put shortly, what was being scrutinised by the court was a different section in a different part of the Act. So there it was. At that point, we thought, well, that's the end of any idea of criminality just being alleged, some criminality, and the law enforcement agencies wouldn't be able to just say money laundering, because you'd have to go further. Nonetheless, the next year, that is exactly what the UKBA did. They stopped somebody at City of London Airport. This guy had over £500,000 in cash in his luggage. His name is Vice, and it is the case of Vice and UKBA. 2012 High Court appeal by way case stated. Mr. Vice was one of the richest men in South Africa. He had a legitimate explanation for his money, had a legitimate explanation for carrying it around in cash. Nonetheless, the Magistrates' Court made the order. The Crown Court upheld it, and it went on appeal to the High Court. And Mr. Justice Underhill, following the Angus case, said more specificity is needed where that allegation is made before the court can conclude that the money was recoverable property. And a failure to do so was fatal, in his words. So I've troubled you with all of those cases, Green, Louboutin, Angus and Vice, to show you how the development of recoverable property and obtaining developed in both cash cases and in High Court cases, and how the High Court has influenced cash cases and now account freezing order cases. But this is all quite old law, but the recent trend seems to be in getting round the problem of having to prove a background offence by not bothering at all with the concept of recoverable property, and instead alleging that the money is going to be used for some future unknown criminal conduct. And we'll come on to that in a minute. I say unknown, but money laundering raises its ugly head again. We see that, in fact, in a case called Fletcher Fletcher and Chief Constable of Leicestershire Police. It's a 2013 case, and it is, in my view, and a lot of what I say is just going to be my view of the case law, is a classic example of how hard cases make bad law. So Fletcher was unique, with unusual facts, almost unique, and it seems to be setting the trend for future cases, because what happened in the Fletcher case is that there was a property in Leicester, and it was rented out, but for some period of time it was left empty, and the property caught fire. And the owner of the property asked Mr. Fletcher, a builder, to go along and refurbish the property. He did so, and while doing so, he found under the kitchen sink hidden away a metal box. In that metal box was £18,000 in cash. And Mr. Fletcher, being an honest man, took that cash to the police. He really did. And the police said, we'll have that. And they took it to the magistrate's court and they got their order. And in the magistrate's court and in the Crown Court, it was argued, and the Anwar case was argued, that the money was, on all the irresistible inference was that the money was the proceeds of crime. And the High Court said this, that applying that second limb, section 298 in cash cases, that the property was intended by use by any person for unlawful conduct, then the finding was correct, because the logic went like this. That the person that hid the money, the hider, must have intended at some future point to use that money in some way, because it's cash and that's all that you can do with cash. At which point he or she would have been guilty of a money laundering offence, because there was an irresistible inference that that cash was the proceeds of some crime. Of course, was referred to the Carol Angus case, but they rejected the Angus case on the basis that Angus was all about section 242, recoverable property, not the second limb of future use. Now, Fletcher is, in my view, my respectful view, bad law for at least 3 reasons. First of all, Lady Justice Nicola Davis in Angus, her ruling, of course, it was specifically about section 242 and the concept of recoverable property. But as I've just been through, she specifically looked at the case of Anwar, and she specifically rejected the idea that Part 7 could be of assistance in Part 5 cases. Secondly, vice was not argued. Of course, it was the same point, but it was just given a little bit more weight. And thirdly and finally, if you think about it, if the Fletcher case is correct, that presents a coach and horses through the whole point of having the concept of recoverable property at all. Because if Fletcher is right, then in any cash case, and that includes account cases, cash in a bank, if the prosecution or the police or National Crime Agency are able to say, we think this is dodgy, and there is an irresistible inference that it's dodgy, that's it, they're home. Because after that, you're going to, at some point, transfer the money or spend it or move it or do something with it, because that's the nature of the beast, cash or cash in a bank account. So if that's right, then what's the point of having the whole concept of recoverable property, which of course was the whole point of the Angus case. But that's just my view. I have to say that there's been a case more recently, last year, Sandu and Chief Constable of West Midlands. And it came up again, Mr. Sandu's house was searched apparently and lots of money was found, and he didn't have a legitimate explanation, and the allegation of this future use was put. So you can see how you have a one extreme case then applied to a much more regular, ordinary case, and the court followed the Fletcher case and said, well, it looks like he was going to use it at some point in the future, and it seems there is an irresistible inference here. So there we are. Perhaps that's the future battleground for account freezing orders. Perhaps we have to have another Carol Angus case. I have to say, though, that when it comes to account freezing orders, it is going to be a bit more difficult for law enforcement agencies to say, that there is an irresistible inference that the money in the bank account is the proceeds of some crime. It's not quite the same as the car park at night scenario, with cash being handed over in a plastic bag when you're dealing with bank accounts. But nonetheless, watch this space, because we suspect there'll be further arguments on this point at some point in the future. So moving on to an entirely different topic, Rich has mentioned the case of Gale. I was instructed by Rahman Ravelli on that, so there is no way I was going to get away with not talking about this case. Article 6, the right to silence, the right to a fair trial, the right to be presumed innocent, etc. It's all going to be very relevant in the test cases and account freezing orders and account forfeiture orders going forward, we predict. I can see the day when a defendant is acquitted by a jury in a Crown Court of, let's say, a fraud offence, only to find that the very next day his bank account is frozen by an account freezing order made by the magistrates, perhaps taken out by the same police officers who've just failed to get the conviction in the Crown Court. Only this time they've got home on a civil standard in the magistrates' court. Does that sound far-fetched or dystopian or Kafkaesque? Well, it's already happening. It's happening in the magistrates. Sorry, it's happening in the High Court. So if it can happen in the High Court, it can certainly happen in the magistrates' court. We've seen already a number of cases where people have been acquitted in the Crown Court, only to find themselves facing the same allegations, essentially, in the High Court. Nicola and I have got a case on at the moment, Mr. M, who is being pursued with civil recovery proceedings after a police investigation, a very lengthy surveillance operation against him. And he was accused of conspiracy to supply Class A drugs. And he gave evidence in his criminal trial, and he was cross-examined. And particularly dates were put to him, surveillance was put to him, photographs were put to him, telephone calls were put to him, and he gave explanations for all of them, and he was acquitted. Those same phone calls, those same surveillance, that same surveillance evidence is now part of this civil case. I've just been instructed on a case where it's a politically exposed person, a PEP, where law enforcement from an overseas country appear to be liaising with law enforcement here, and we suspect using the account freezing provisions over here to assist the overseas investigation. Another case where partners are involved, and the male partner is being prosecuted for drugs offences, but there is no evidence against the female partner, but she does have a bank account with lots of money. And so she finds herself in the magistrates' courts with an account freezing order. So you've got linked tandem criminal and civil proceedings, rather than her being added to the indictment as either a co-conspirator or a money launderer. So Article 6, every single one of those scenarios that I've pointed out in some way or another engages Article 6. And the lead case on Article 6 and Part 5 is, of course, Gale and Soccer in 2011, the Supreme Court. Mr. Gale was a British national living in Portugal, an interesting man, and he had his own aircraft and his own airfield, and he was flying backwards and forwards to North Africa. And the allegation was that he was bringing back lots and lots of cannabis. Same with boats over to Spain and then onwards to Portugal. And he had a trial and he was acquitted. A number of people were convicted, but he was acquitted. And in the Portuguese proceedings, there was no jury, there was a panel of judges. And so they actually gave reasoned judgments. And Soccer, as they then were, relied on this reasoned judgment, or the bits of it that made him look guilty. Not the bit at the end that said, you are not guilty. They added to that some intelligence evidence, historic intelligence evidence from here that suggested that he'd been involved in drug trafficking years ago. And then, of course, applied the civil standard. So the basic arguments for spending too much time on Article 6 was that when you're bringing subsequent proceedings after an acquittal, that it's unlawful to do that, to go behind the conviction effectively, because to do so would be to violate the right to be presumed innocent. And if you are going to do that, then at the very least, the procedural protection must be that the allegations must be proven to the criminal standard. On our side, we had lots of case law supporting that, most of it from Strasbourg, but we had UK House of Lords case, Briggs Price, all supporting that proposition. And essentially from Strasbourg, the case law was about linked proceedings. So, for example, there's a case called Scania and Austria. Mr. Scania, acquitted of rape, then said to the court in separate proceedings, but in the same court, can I have money for compensation, please? And they said, no, because we think you're guilty. That went to Strasbourg, and Strasbourg said, well, even the voicing of suspicions was the phrase that's used, even the voicing of suspicions after an acquittal on linked proceedings is a violation of Article 6.2, the right to a fair trial. The UK Supreme Court held that the criminal standard of proof did not apply in David Gale's case. The Portuguese court, of course, was not procedurally linked to Soccer's claim, nor did we ever suggest it was. We said the link can be there by the use of language. The Supreme Court looked at the Strasbourg case law and suggested that the European Court of Human Rights had taken a wrong turn, to quote Lord Phillips, and suggested that what the court actually meant was that where a public authority, what a public authority could never do was suggest that an acquitted defendant should have been convicted on the application of the criminal standard of proof. That, of course, runs against what the case law was actually saying, even the voicing of suspicions. But perhaps that's why Lord Phillips, in the same paragraph, said that the confusing area, this confusing area of Strasbourg case law would benefit from consideration by the Grand Chamber. So we got very excited and took that as an invitation to go off to Strasbourg. And then sadly, we were beaten to the post by another UK case, Allen and the United Kingdom. That was decided by the Grand Chamber in July 2013. Mrs. Allen was convicted of a baby shaking case, and then the Court of Appeal quashed her conviction, and she asked for compensation as a miscarriage of justice, and she didn't get it, and she went all the way to the Grand Chamber with it, making these Article 6.2 points. And she didn't get very far there, but the Grand Chamber took the opportunity to say that whenever anybody's relying on this concept of Article 6, especially Article 6.2, the right to be presumed innocent, in subsequent proceedings after an acquittal, then the applicant must demonstrate the existence of a link. And then, just to quote very shortly from the ruling, such a link is likely to be present where in the subsequent proceedings, for example, and it gives a list of examples, the court is obliged to engage in a review or evaluation of the evidence in the criminal file, to assess the applicant's participation in some or all of the events leading to the criminal charge, or to comment on the subsisting indications of the applicant's possible guilt. It's quite a wide definition, and that establishes the link. It doesn't have to be physically the same building or in linked, procedurally linked cases. As I say, Nicola and I have this case that I've just described, Mr. Wren, where the NCA are actually relying on the physical evidence from the trial that he was acquitted in. So perhaps watch this space. We'll see what happens with that case. It may be that that's the next case which retests the boundaries of Gale. In our view, the National Crime Agency are stretching Gale beyond its limits. So let's see what happens in that case. But that's quite enough from me. I'm going to hand you back over now to Nicola, who's going to tell you all about account freezing and forfeiture orders.
Thank you, John. Turning now to account freezing and forfeiture proceedings. Now, as I explained earlier, the new powers were inserted into Chapter 3 of Part 5 of POCA by the Criminal Finances Act 2017, and you'll find the relevant sections at 303Z1 to 303Z19. Now, these new powers basically extend the already well-established cash forfeiture process to include bank and building society accounts. The procedure is practically the same, and the concept of recoverable property that John's just been through in detail applies. Therefore, in order to run through the procedure for obtaining an account freezing order, I'll run through a typical example. So, we have a police officer and he's conducting some desk-based inquiries into a suspect. As part of his investigation, he wants to have a look at the suspect's bank accounts. So let's say the officer gets a production order and he gets the bank statements. Now, upon considering the bank statements, he sees what he thinks is some suspicious activity. Now, this could be large sums being deposited into the account, or money coming in from unknown or unusual sources, or what we tend to see a lot is money coming in from various companies. And when the officer looks into these companies a bit further, they don't exactly seem legitimate, maybe a bit suspect, they may be fairly new, they've got a very low web presence, and so it heightens his suspicions. So on the back of that, he decides he may well go along for an account freezing order. Now, with cash detention, the fact that a criminal investigation is ongoing is no bar to making a civil application for the detention of cash. Indeed, a civil order can be continued where a criminal investigation is ongoing. So effectively, it's like a restraint order for cash. And obviously, it's more difficult when we're dealing with bank accounts. Now, do the police go down the restraint order route based on an expectation of criminal proceedings, or do they look to the newly popular account freezing orders? So in this example, we'll say that he decides he's going down the civil account freezing order route. The next step, the officer will make an application to the magistrate's court for an account freezing order, and this can be made without notice. The process is relatively straightforward, and just like cash detention, the test is very low. To actually make the application, section 303Z1 states that an enforcement officer has to have reasonable grounds for suspecting that the money held in the account is either recoverable property or is intended by any person for use in unlawful conduct, everything that John's just been through. The application has to be made by an enforcement officer, and that can be a police officer, HMRC, SFO, or an accredited financial investigator. The minimum amount that can be frozen is just £1,000, and the maximum period of an order is 2 years. So the officer makes his application because he or she has the reasonable suspicion requisite. Now, in order to actually make the order, the court itself has to be satisfied that there are reasonable grounds for suspecting that the money in the account is either recoverable property or intended for use in unlawful conduct. So you'll see that the test is very low, and the police officer only has to have his own reasonable suspicion, and the court only have to be satisfied that there are these reasonable suspicions, a very low test. Therefore, it's more than likely that the officer is going to get his account freezing order. So what happens next? Well, the next step is that the account holder or respondent receives the account freezing order. Or before he or she receives it, they may have even attempted to access their bank account only to find out it's been frozen. In a state of panic, they contact a solicitor for advice and assistance. Now, at this stage, the respondent really has three options. Now, firstly, do nothing. Wait for the police to make a forfeiture notice or a forfeiture application. Secondly, apply for the release of the money that's been frozen immediately. Or thirdly, wait until the police make an application to extend the account freezing order. Because whilst there is a maximum for account freezing orders of 2 years, in reality, when the magistrates make the order, it will normally be for a period of 3 or 6 months. So in this case, we'll say it's 6 months. As the 6 months approaches, if the officer needs more time, they'll have to make an application back to the court for an extension of the order. So let's say in our scenario, our respondent opts for option 3, i.e. decides to do nothing and wait until the officer tries to extend the order and then object. Now, at this stage, there could well be a good argument to the challenge of the officer's reasonable suspicion. Is his or her reasonable suspicion still reasonable now, 6 months on? At this point, you'd also want to question exactly what, if anything, has the officer been doing since the order was made. It's worth bearing in mind at this stage how things work in the criminal sphere, where the restraint order is in place. Now, restraint orders don't have to have a time limit and can continue all the way to conclusion of a trial or even confiscation. However, even though there's no time limit, there is a discipline with restraint orders. The Serious Crime Act 2015 effectively did two things in relation to restraint orders. Firstly, it lowered the test from reasonable belief to reasonable suspicion, but it also imposed a reporting requirement. Usually, every 3 or 6 months, the investigation agency has to update the court with a report on the progress of the investigation. Now, with account freezing orders, there are no reporting requirements. There's a time limit of up to 2 years, but no provision for the officer to provide any updates. Now, as the account freezing order, like I said, will initially have been made for a period of, let's say, 6 months, the officer will be required to go back to the magistrate's court to make that application for an extension. Now, this basically has the effect of a reporting requirement, because at that stage, the officer's going to have to go and explain why he needs more time. This happens with cash forfeiture all the time, and it's a perfect opportunity to contest and argue as to whether the suspicion is still reasonable suspicion after inquiries have been made. The officer can be challenged at this extension stage as to why they are not ready to make the application or to release the money, and what exactly have the police been doing. Now, if they've been effectively sat on their hands for the last 6 months, whilst the respondent's been having to deal with the difficulties of having his account frozen, then you may want to challenge how the officer can still plead that his suspicions are still reasonable. These are all issues to be considered when making any objection or challenge. In reality, it's likely that the first application by the officer to the magistrate's court for an extension will be granted, even in the face of opposition. But what about the next phase, when they come back again a further 6 months later, requesting more time? The pressure is on for the police to conduct thorough investigations and be cross-examined about them. And it's all going to boil down to the test of whether the suspicions remain reasonable. Now, I'll now turn to the next stage of forfeiture. Now, at any point during the life of an account freezing order, the enforcement officer can make an application for forfeiture. And with forfeiture, there are effectively really two routes: contested route and the administrative route. Now, with the contested route, just as with cash, objections can be made to the order, and effectively the matter will be listed for a contested hearing in the magistrate's court. And under section 303Z14, it states that where there is an account freezing order in place, an application for an account forfeiture order may be made, and the court will make the order if the court is satisfied, it's not reasonable suspicion anymore, it's satisfied that the money is recoverable property or is intended by any person for use in unlawful conduct. Looking at the administrative route, this is effectively where the account's been frozen, but there's been absolutely no engagement from the account holder. Under this process, there's no real consideration of the evidence, there's no representations from the respondent, and instead it happens by service of a forfeiture notice under section 303Z9, and that'll give at least 30 days for the respondent to object. If there's no objection within the time frame, then that money is forfeited. Now, there is one procedural hole that an over-eager investigator could fall down, and this is something that has happened in a case that John was involved in recently. Now, it's worth noting that the administrative process is there to make things happen quickly where there is going to be an opposition. So in the case I'm referring to, the police messed up is the reality of it. The financial investigator got the account freezing order. There were then discussions with the person concerned, the respondent, who wasn't represented actually at the time. The financial investigator had material sent to her from the respondent, and certainly knew of an objection to the account forfeiture order being made. It then appears that the financial investigator became somewhat frustrated at a later lack of communication from the respondent and decided to issue a 30-day forfeiture notice under section 303Z9. Now, under the administrative procedure for forfeiture orders, the order would have been made at the end of those 30 days because the evidence is there, no one's objected. However, with this client, when she received the order, they went along to the solicitors, and with days to spare, the solicitors managed to issue a formal objection on day 26, so just before the 30-day time limit. The effect of the formal objection was that the forfeiture notice lapsed, and the account freezing order then ceases to have effect at the end of the period of 48 hours, starting with the making of the objection. You can find that under section 303Z11. The only exceptions to an account freezing order ending 48 hours after the objection to the notice is where, within that 48-hour window, an application is made by the enforcement officer for either forfeiture or for an extension to the account freezing order. Parliament clearly kept these time limits strict and short deliberately. In this case, although the financial investigator wanted a quick result, which is why she issued the forfeiture notice in the first place, what she failed to do was then act quickly herself when there was an objection, i.e. within the 48-hour time frame. She did in fact make an application to the court for an extension, but outside of the 48-hour period. The respondent therefore objected, judicial review was threatened, and the money had to be handed back to the client immediately. And I'm sure that resulted in a very happy client, John. Now, that was a brief run through of the account freezing and forfeiture process, and it touched upon some potential areas of challenge. But now I'd like to turn to some very practical matters that will no doubt be of interest to a lot of you. Firstly, I'm going to be looking at defence costs. Where the client's money is tied up in an account freezing order, what do you do? And then lastly, John will take us through a scenario whereby the applicant loses and whether you can claim your client's costs back. So looking at defence legal costs and variations for reasonable legal expenses. Now, the first thing to say is that life's obviously a lot easier if your client has unfrozen assets to pay the legal expenses. But if that's not the case, what can be done? Now, as previously discussed, the account freezing order regime is modelled very closely on the cash forfeiture process. But in cash forfeiture proceedings, there are no provisions to allow for the variation of the detention order to meet reasonable legal expenses. But there is in High Court civil recovery cases where there is a freezing order and it's a property freezing order. Now, the new sections of the account freezing order regime specifically point to the process for exclusions from property freezing orders in the High Court under Part 5 of POCA. And just as there's plenty of case law on Part 5 from the civil recovery jurisdiction as to the topic of recoverable property and obtaining that John's taken us through, there's also case law and guidance there too on the topics of exclusions for legal expenses. Now, turning to the Act and the insertions of the account freezing order, Section 303Z5, subsection 3 of POCA deals with exclusions from the account freezing order, and it allows the court to exclude from the order money for reasonable living expenses and exclusions for the respondent to carry on a business or a trade. More interestingly, under Section 303Z5, subsection 5, this allows the court to make an exclusion for the purpose of meeting the respondent's legal expenses. It's subject to 3 conditions. The first is that it's limited to reasonable legal expenses. Second, it specifies the total amount to be released. And third is that it's made subject to the same conditions as would be required conditions in Section 286A of POCA. Now, 286A relates to property freezing orders and an established procedure that is set out in the Proceeds of Crime 2002 Legal Expenses in Civil Recovery Regulations 2005, which we've been using for years in relation to exclusions for legal expenses from property freezing orders, where the respondent has got obviously no other available means. Looking at the regulations set out the conditions for the release of monies. The required conditions set out within the 2005 regulations deal with a number of practical matters when it comes to applying for an exclusion, such as an exclusion must specify the stage or stages in the proceedings to which the exclusion relates. And it must also set out the maximum amount required for that stage. So this stage could be a date range. It could be for the stage leading up to a directions hearing, for example. I mean, the stage can be whatever you want it to be. The required conditions also deal with the procedure for interim payments, so payments before the case concludes. And requests for interim payments can actually be made every 2 months. And under the regulations, within 21 days of the request for payment, the enforcement officer must either agree to the release of the requested funds or confirm the amount that they are willing to release, along with reasons for the decision. Now, at that stage, when you get the reasons back, you may well be able to enter into further negotiations as to what they consider reasonable and what you consider reasonable. But in any event, the sum that will be released from the exclusion is either going to be the greater of the amount that the officer is offering or 65% of your requested sum. The condition also sets out a table of rates that may be charged by solicitors and counsel. Now, it provides for standard and higher rates. Now, unfortunately, there just isn't time in this webinar to look into examples of the types of cases that warrant the higher rates. But the conditions do state that higher rates are only allowed where the case involves substantial, novel, or complex issues of law or fact. The rates set out for standard rates for a solicitor of at least 8 years standing is £187.50. The higher rates £225. For counsel of at least 10 years call, the standard rate is £150. The higher rate is £225. As you can probably tell, these rates haven't actually changed in 15 years. There's also a 20% increase in the rates for legal representatives whose offices are situated in central London and 10% for those in outer London. Now, there's nothing in the 2005 regulations about how to resolve cost disputes in property freezing order cases, or even disputes about entitlement to access the frozen assets. However, in property freezing order cases, it's not just the regulations, but also civil procedure rules, or rather practice direction on civil recovery proceedings that deals with those issues. Now, whilst the practice direction is not of direct application in account freezing order cases, it's difficult to see how it can be ignored, given that Parliament clearly intended for the magistrates to follow the High Court process when it comes to legal expenses. Therefore, should you find that you're in dispute with the enforcement officer as to whether exclusions can be made from the frozen account for legal expenses, then look to the property freezing order regime, see how it works there, and specifically look at the CPR practice direction. Now, under Part 7A of the practice direction, it states that in cases of a property freezing order, before any exclusions can be made, there should be a statement of assets provided by the respondent in order to confirm that they have no other available assets. Now, this is to prove that there are no other unfrozen assets that can be used for his legal expenses. The same procedure really should therefore be applied when looking to request exclusions from an account freezing order. So, no variation until you get a statement of assets. But how does a solicitor get paid for preparing the statement of assets? Now, that answer can also be found in the practice direction at 5B.1, which provides for an initial, no arguments, exclusion of up to £3,000 to enable the respondent to meet his or her reasonable legal costs in order to take advice on the order and to prepare the statement of assets. Now, once the respondent has provided the statement of assets, then if the officer agrees the need for an exclusion, then negotiations can commence. And I'll come on to that part shortly. But what if the officer still objects to any exclusion based on their suspicions that the respondent does indeed have other assets, and basically that they don't believe what's been said in the statement of assets? Now, the answer there lies in the civil recovery case of POCA versus Azam, 2013. In brief, in that case, Mrs. Azam was just not believed. Her statement of assets said that she had no sufficient free assets to pay for her legal representation, but she wasn't a credible witness. But even so, the Court of Appeal found that she could not be asked to prove a negative and prove that she doesn't have money elsewhere. The court found that, in fact, the statutory regime applied a lien towards the release of monies for representation and thus a steer towards a variation being made. So basically, this case outlines that even where there is doubt or suspicion, the court should lean towards granting an exclusion. In summary, whilst there is no tested case as yet for exclusions for account freezing orders, on the basis that the exclusions principle for these orders has been modelled on the property freezing order, then upon dealing with exclusions for legal expenses, the following practical steps I suggest should apply. Firstly, prepare your client's statement of assets. Ensure the enforcement officer is aware of the statutory instrument for the release of the initial £3,000 for the legal expenses. Under the 2005 regulations, you can only make an application for legal costs incurred. So there is a risk there, but offset that by the 65% rule in the regulations, and also offset that by the solicitor if the solicitor seeks agreement from the enforcement officer in advance. Now, if the officer rejects the statement of assets and objects to any exclusion, then you're going to have to work at some risk. So I'd suggest you keep that stage short. On the other hand, if the officer agrees in principle to the release of money to pay for legal expenses, start negotiating your first stage in an attempt to agree reasonable legal expenses, which can then be put before the court at the end of that stage as effectively an agreed order. After the stage is complete, you can submit your bill to your client and a variation request under 2005 regulations to the court. Now, this should be straightforward if the costs have been agreed in advance with the officer, and it can normally then just be done by way of a consent order. However, if not, then the police are obliged to agree to the release of 65% of the bill. As for the remainder, with property freezing orders, there is a High Court taxing regime, and the CPR practice direction specifically caters for this situation. And it effectively dealt with as a cost taxation issue. It's dealt with on the papers, straightforward, and it's binding. But it's not possible for account freezing order cases, and this is where there appears to be a gap in the system. In our view, is that in that scenario, an application should be made to the Magistrate Court for a variation under section 303Z5. In effect, you're asking the court to tax your fees. Now, I guess the real key is to try and agree as much as you can in advance with the enforcement officer. But of course, this is going to depend on who exactly you're dealing with. Now, you're probably glad to know that we're now moving on to the final section of today's webinar, and I'm therefore going to hand you over to John, who's going to look at the scenario whereby the applicant is unsuccessful and whether you can actually claim back your client's costs. John, over to you.
Thank you, Nicola. Apologies to everybody because I think the sound quality my last bit wasn't great. Hopefully this is a wee bit better. This part shouldn't take long. It just brings us to the end of our presentation. I'm just going to talk to you about the rule in peri-penathem. So as Nicola says, this is where you're representing a client, an individual or a corporation, and you've successfully fought off an account forfeiture order application or a cash forfeiture order application, and your client wants their legal expenses back, unsurprisingly. Well, you've got to tell them that, in fact, even if you win, there's a very good chance that they're not going to get their money back. That's because the civil jurisdiction of the magistrates' courts when it comes to costs is all in section 64. Section 64 of the Magistrates' Courts Act 1980. And that provision was considered in peri-penathem, a case called peri-penathem, Westminster Magistrates' Courts and Metropolitan Police in 2010, Court of Appeal case. And just very briefly in the facts of that, Mrs. Peri-Penathem sent her 15-year-old daughter abroad with £150,000 in cash in her bag to give to her uncle in Sri Lanka. The daughter came back from overseas still with £150,000 in cash, and there was some account that in fact she hadn't met her uncle, so she came home with the money. She was stopped at Heathrow Airport. They discovered the money. She was arrested and she was interviewed. Her mother was also at the airport to meet her, and she was interviewed, and they basically gave the same account, which was to the effect that the mother ran a bureau de change business, and that involved cash, and she was just using her daughter to carry cash to Sri Lanka, and it was destined for 3 particular businesses, and the 3 businesses were named and investigated, and the accounts held up. Nonetheless, the police made an application for forfeiture on the basis that the money was for use in unlawful future conduct. And unlawful future conduct being the funding of terrorists. It was said that the money was going to the Tamil Tigers terrorist group in Sri Lanka. The police found that one person that worked for one of the 3 companies identified had some very loose connection with the Tamil Tigers, and relied on a paper that said that the Tamil Tigers, one of the ways that they fund terrorism is by pressurising Sri Lankans living overseas to bring money to them. This got nowhere with the Magistrates' Court, and the application for forfeiture failed. Then, when costs were asked for, it was refused, and the court relied on the case of City of Bradford and Booth, a 1999 case. In that case, the court, considering the civil jurisdiction of the Magistrates' Court to apply costs, section 64, said, and it was Bingham, said that when a public authority is acting honestly, reasonably, properly, and on grounds that reasonably appeared to be sound in the exercise of its public duty, then it was not right to make an order for costs against the public authority even when they lost, because to do so would be to discourage them from carrying out their statutory duties. It would have a chilling effect on bringing cases to court for the fear of it costing money. So the question for Perry Penathan was, did that rule, the rule in Booth, apply in cash forfeiture cases and Part 5 cases? And the answer is yes. Yes, it did, for all the same reasons. In Perry Penathan, the court said it was perhaps significant that there had been no application for the release of the monies at any stage. Basically, it all turned on the hearing. The moral of the story is that, unfortunately, you do have to advise your clients that there's every chance that they're going to lose their money, even if successful. But it does put a pressure on those defending respondents in account forfeiture order applications to put the police, to put law enforcement under some pressure, perhaps to resist applications for extensions to AFOs or make applications for the release of the money. Because as Nicola was saying, when explanations are given at an early stage for the derivation of the money, and the police perhaps are seen not to do their job particularly well, or there is question marks that come up along the road, and 6 months later at the end of the proceedings the police appear to have done nothing more, then there is an argument potentially there, depending on the facts, that the police haven't acted reasonably, or they haven't acted reasonably in continuing the proceedings. There's a case called Burdett and Devon County Council. It's a 2014 Queen's Bench Division case where the district judge refused to award costs against a successful respondent in a local authority case. And that decision was overturned by the Queen's Bench Division, who said, well, actually, the district judge had failed to take account of the behaviour of the local authority to his own prior findings of fact in determining whether the local authority had acted reasonably in either instituting the proceedings in the first place or then continuing the proceedings as the case developed. So with all that in mind, it can sometimes be worth making applications just in order to protect your costs position at a later date. And that's really all there is to say about Perry Penathan. So I'm going to stop talking now and hand you back to Richard. Thank you for listening.
Thank you, Jonathan. And thank you, Nicola. Please now imagine a rousing round of applause being delivered countrywide. You both thoroughly deserve it. We've got a couple of minutes, perhaps, for some questions. We have received some, and what I'll do is I'll read the questions out, and then perhaps we'll have a quick discussion or try and answer those by giving some headlines. The first question come in from Joseph Hill. Does the forfeiture hearing itself have to take place within the 2 years of the freezing order? With COVID, forfeiture hearings may take place outside the 2 years' time. Seeing as both you, Nicola and Jonathan, were rather busy, I had a quick look myself, and my initial thoughts on this would be it depends perhaps on the definition and interpretation of the wording in section 303Z14, which is the forfeiture order section, which says in subsection 1, this section applies, and these may be the important words, while an account freezing order has effect. And as we know, ordinarily account freezing orders can have effect for a period of 2 years, which may explain the question. But what it goes on to say in subsection 2 is an application for the forfeiture of money held in the frozen account may be made to the magistrate's court or the sheriff if it's in Scotland. Now, does that mean, an application, does that mean the hearing, or giving notice of an application? So this is not a situation that Nicola went through where it's an account forfeiture notice sort of account forfeiture. It's where an order is sought by way of a hearing. So does that mean, therefore, if there's an account freezing order, forgive me, and it's nearing the end of the 2-year period, and the police officers or whoever the enforcement officer is submits a written application in the proper form, does that satisfy the words "an application," such that in effect the 2-year period effectively stalls and is paused until there is an actual forfeiture hearing, which of course with COVID and with the courts the way that they are, would be beyond that? I mean, that's my initial thoughts. Nicola, Jonathan, what do you think?
Yeah, that is exactly the position as I understand it, Richard. This used to come up in cash cases. It will come up again in account cases. COVID isn't going to trouble the courts quite so much, because the time limit is for the application, not the hearing. I've got a case, in fact, with Nicola, where it's a property freezing order, where so the time limit is set by the order, and it is for an application to extend the order, and under the provisions of the order, any application had to be made by X date, and the application was for an extension for 6 months, and the application was made just a few days before the cut-off date, and we objected, and so we're having a hearing in 6 months' time, by which time, of course, it's pointless. But that's just an accident of listing, in that case in the High Court, but it's exactly the same under the statutory provisions for the Magistrates' Court.
Yeah, I think just on that, I think there is going to be some difficulty presently with COVID. I was dealing with an account freezing order matter yesterday, which is a series of corporate accounts, and several million in there, which will effectively stop the business from running. And the earliest date that we could get for an application to set them aside, initially we were told, was the end of March. And this is a business that would effectively shut down within the next month or so. Subsequently, we managed to get a hearing date in the middle of January, so not quite so long away. Anyway, so I think, yes, 303Z14, subsections 1, 2, and possibly also 8, to have a look at that to answer the Joseph Hill question. The second question we received, the anonymous attendee, we don't know who you are. Should a respondent object to AFO extensions given the low thresholds? As we're at 14 minutes past 5, now it's 15 minutes past 5, I think Nicola dealt with this in some detail, looking at the considerations. Often it's going to be very fact specific, depending on what the nature of the initial basis for the freezing order was. And then, of course, depending on where it is it an application to extend one that's only been in place for 3 months, or is it one that's been in place for 9, 12, 18, or nearly 24 months? What have the officers done? Issues like that. So I think, unless anybody else wants to jump in and add to that, I think the answer to that is, well, it's very fact specific. Yes, the threshold for an extension is low, but that doesn't mean that you shouldn't scrutinize it and give it a good look and perhaps challenge it, because there may not be anything, of course, to be lost by challenging. So would that do for a simple answer for that?
I think so, and I think also touching on what John has just gone over with regards to if it comes to potentially getting your costs back, whether you've been making those challenges, which John covered, as well as the synopsis of what I said. Okay,
great. Well, look, we're now a minute past what we said would be the length of the seminar, which I think is a credit to you both. the after event groups, group drinks, nibbles and networking that would normally follow, I'm afraid we'll also have to imagine. If you've got your own stash of whatsits to tuck into and a glass of something reassuring to hand, then perhaps whilst you enjoy those, you'll each look forward to the next occasion when we might all congregate together, and hopefully that's not too far off. If there are any other follow-up questions or inquiries, please of course make contact with the clerks at Doughty Street or with Rahman Ravelli. It just leaves me to again thank you all for attending. Thank you, Nicola. Thank you, Jonathan. Thank you for tuning in, and goodbye.